Hello, Charlotte.
Hello. Okay. We are now live with our subcommittee on family and juvenile law. We're meeting today, which is Monday, March the 10th, 1 p.m. And we're going to go ahead and get started with our first bill of the day, which is HB 246. And if I can have Justin Hayes or someone from DHS, that'd be great. But in the meantime, I will try to summarize the bill. Okay, and I see Sarah. Okay, perfect. All right. Um, so let me see. Okay, there you are. Okay, DHS. Perfect. All right. So we're starting with HB 246. Gonna go ahead. I'm gonna try to attempt to summarize it, and of course, I may need some help from you all as well. But anyway, a bill allows the Adult Protective Services to actually share information with other agency partners who are responsible for investigations. There is an amendment to the bill, and what I'd like to do is let DHS have an opportunity to speak, and then we will take it from there. So go ahead, Justin, if you'd like to just chime
Madam
in
Chair,
and share a little bit more about the bill and what it does. Oh, and
Madam
there's
Chair,
Mhm.
Justin Hayes, Deputy Director of Government Affairs for DHS. We have another gentleman on the call who has not been let into the room yet. If you could let Greg Sessick, who is the head of our APS division, into the call,
Okay.
that would be great.
All right, here he comes now. Perfect. All right.
All right. So, good afternoon, everyone. Again, my name is Justin Hayes. I'm the Deputy Director of the Office of Government Affairs for the Department of Human Services. And this bill very broadly would permit the data sharing of adult protective services records with state and local law enforcement. And I will leave it very brief and very broad there. And if anyone has any specific questions about the scope of the bill, my colleague Greg Sessick is also on the call, and he's available to answer any additional questions on it.
Okay. And I also understand that
I'm trying. I'm going to try for 5 minutes.
Delegate Kaufman, thank you. If you will put yourself on mute. I also understand that there is someone here from Maryland Department of Health, and that's Miss Case Heron. Perfect. If you will, yeah. And if you will comment and let us know how this bill, I understand this bill also has some changes that might have been requested by if it's not your organization, I know that you guys also weighed in. If you could give us some comments.
Yes, we did not request any amendments on this bill, but we were a letter of support supporting DHS because we are one of the state departments that this information sharing bill, like these changes would assist with because it would streamline our processes with DHS. So we just are on to support our colleagues.
Okay.
And their bill, which we think will be helpful for us.
Okay. Great. Okay. And I know also, Justin, that there were some amendments, and Lauren, do you want to help me talk to those amendments? They were, I think, amendments to specifically requested by the Maryland Institute for Emergency Medical Services.
Okay.
And I think it was to clarify and to provide more detail on what their efforts would be. But is that kind of what it was, Lauren?
Well, there are two pieces. The first one was saying on page, I think it's continuation of page 2 of the reprint in 14-302 subsection B. It's allowing an individual who's required to make a report to do so by calling the statewide reporting hotline as soon as possible. And then the other provision is in section, again on page 2, about the middle of the page, 14-101. It makes that provision relating to the change to the definition of health practitioner. That part of the bill only has a delayed effective date, which will now take effect July 1, 2026.
Okay. Are there any questions by the committee about the bill?
Yes, Madam Chair, this is Delegate Sample Hughes. I was
Yeah.
just curious about why the delay. Was there a specific reason for the delay of implementation to the 2026?
Sure. And Justin Hayes, can you possibly
Happy
comment?
to.
Okay,
That was one of the amendments that the Maryland Institute for Emergency Medical Services requested. And the purpose for that amendment was just to give them additional time to train their staff, their employees, the EMS personnel that would need to receive that training on this new form of reporting.
Oh, okay. Thank you so much.
thank
We
you.
consider that a friendly amendment from our colleagues at MEMS.
Okay.
Yes.
I'm in the car and can't find the raise hand function, but when
Delegate
it's my
Cop-
term, I would like Mike to speak.
Okay, Delegate Kaufman, hold on for a second. All right, Delegate Taylor, go ahead.
Thank you, Madam Chair. What's the history behind this? Why can't this information be shared now? And is there some reason why in the past it wasn't allowed and now we think it's a good thing to do?
Would you like to speak to that, Mr. Hayes?
I'll actually defer to my colleague, Mr. Stesic, on this one,
Okay.
who has a little bit more legislative history on that.
Sure. Go ahead, Mr. Sessick.
Hi, thank you for your question. So right now it is possible to share APS records with other governmental entities who participate in investigations around vulnerable adult maltreatment, but it requires a court order. That really slows down other entities in obtaining that information more quickly. One of the agencies this impacts is the Office of the Chief Medical Examiner. So we do currently share information. It's just that we can't do so without a court order.
Thank you.
Okay, any other follow-up question to that? Okay. All right, Delegate Kaufman, you're next. Now you're muted. Can you unmute yourself, Delegate Kaufman?
Yes.
Perfect.
My question is, could ask to remind us if there was any opposition to the bill, and if so, who was opposed?
No, I do not believe there was any opposition to the bill, and I will confirm that in a couple of
No opposition.
20, 30 seconds. Okay. All right. Any other
Okay.
questions? Go ahead, Delegate Taylor. Did you have a follow-up question or?
I do. My brain wasn't moving fast enough. I kind of knew that already, that a court order is what's required now. So I guess my real question is, was that put in place for a reason that it had to be a court order? Was there, what was the necessity of that when that was imposed, and why do we think now we don't really need that level of scrutiny?
Who would like to answer that from DHS? Mr. Sessick?
Hi, thank you. I can't really I can't answer the question except what I understand to be the case is now we have in Adult Protective Services a statewide data and case management system, which makes it easier in a way and more functional for us to share records. This wasn't the case prior to 4 years ago, and I think probably having the court order fell in line with a much slower process at that time for having to request and obtain paper case files. Now we do have the ability to instantly access statewide APS records. Hope that's helpful.
Oh, that's very helpful. Thank you.
Okay, and I see Delegate Bartlett.
Thank you, Madam Chair. I guess my question is also for the same individual, gentleman. You mentioned the Office of the Chief Medical Examiner. Can you tell me, give me for instance or example on when the chief medical examiner is involved or needs the information?
Thank you. Yes, we routinely receive court orders from the Office of the Chief Medical Examiner. It is my understanding there are certain situations whereby APS records are, I'm not sure that I can say required, but certainly helpful in determining the postmortem investigation. We have been receiving more requests for records now that we have our digital data and case management system than I believe was previously the case.
Okay. May I have a follow-up question, Madam Chair?
You may.
So I'm looking really quickly to see if there are limitations with respect to the information that can be shared. And I'm not quite seeing them offhand. I wanted to know if there were any limitations in place.
So this is a function of the central office at DHS. There's a dual review by my office and by the Office of the Attorney General, who's assigned to our office, just to make sure of the appropriateness and the use of the information. But we have not limited the request as I understand it.
And one more quick question.
Sure.
This will be my
Go
last.
ahead.
So when you all go in to get your court order, what are some of the standards that you have to meet in order to be granted the court order?
So I will attempt to answer that on behalf of other agencies who have submitted court orders to us. The court order is delivered to the Office of the Attorney General at DHS, who represents my office. And that in turn is sent to me for review. I can't answer on behalf of the court and what that process may be, though.
I guess what I was asking was, you have to explain why you need the material. So what is a why of why you would need the material in order to present it to the court?
Thank you.
And make that request.
Thank you. Yes, in the orders that I have received, I'm just using the chief medical examiner as an example. It does state that, the reason is for the completion of a postmortem investigation. I don't recall seeing any more specific information than that, however.
Okay, thank you very much. Thank you, Madam Chair.
No problem. Thank you. Okay, any other questions? All right. So we have an amendment to this bill. There's no unfavorable opposition of any kind. And so I'd like to find out if I have a motion on the amendment to the bill.
Motion. So move.
Second.
Thank you. And all those in favor of the amendment, would you raise your hands? Okay, great. Looks like we've got everyone unanimous. All right, so we are going to move on the bill. Let me back up for a second. Any other discussion on the amendment? Okay, oh, Delegate Simpson.
I don't. I think my system Zoom updated, so if I raise my hand, it puts a hand up. I'm not sure if I like it or not.
Because it doesn't go down quickly enough. So
Yeah.
there we go. All right, so do we have a motion on the bill itself? I heard something. I'm not sure what I heard.
Move the bill as amended.
Okay.
So move.
Okay. Perfect. All right. So we're going to do a roll call vote on the bill as amended. So Delegate Bartlett,
Yes.
Delegate Boucher,
Yes, ma'am.
Delegate Kaufman. I'll let him unmute himself. Delegate Pastor.
Yes, can you hear me now? I'm a yes.
I hear you. Thank you. I'm sorry, Delegate Pastor. Go ahead.
Yes.
Okay. Delegate Sample Hughes,
Yes.
Delegate Simmons,
Yes.
Delegate Simpson,
Yes.
Delegate Stinnett,
Yes.
Delegate Taylor,
I'm a yes.
Delegate Tomlinson,
Yes.
Delegate Valentine,
Yes.
and I'm a yes as well. So we have moved that bill out of our subcommittee. All right, our next bill up is HB 950. All right, so I think most of the DHS folks are going to stay on. Okay. And Diana Phillips, and okay, perfect. All right, we'll let folks get in. All right. And we have someone, I think, from Chair Wilson's office. Is that Grace?
Yes, it is. Chair
Okay,
Greenfield.
perfect. Okay, perfect. All right. So would you give us a really quick summary of the bill?
Absolutely. Thank you for this opportunity to speak on behalf of House Bill 950. For the record, I'm Grace Wilson, Senior Legislative and Policy Specialist for Anne Arundel County Public Schools. What this bill does is it permits the Department of Human Services to disclose a report or record regarding child abuse or neglect to the administrator of a child care center, a coach, a team administrator, or a manager of a youth sports program, or the administrator or other appropriate personnel that provides care and control of children. This was an issue that came to the school system as we've received reports of child abuse and neglect and noted that individuals continue to work with students through other organizations in our community. Thank you.
Thank you very much. And I'd like to also have Ms. Phillips to comment because I think you were favorable with amendments, if I'm not mistaken.
Yes, ma'am. Thank you.
Perfect. What were the amendments you were looking for? And tell me a little bit about that.
Yes, so the Coalition to Protect Maryland's Children includes two people that worked with Delegate Wilson on this bill. Wendy Lane with the American Academy of Pediatrics and Alison D'Alessandro with the Center for Hope. Their concern was about coaches. And so we had respectively, and they had also as well independently, I believe, with their two organizations, requested an amendment to exclude coaches from receiving a report or record concerning child abuse regarding an employee. They believe that an administrator at a more senior level position in a youth sporting program should receive such a report because it's important that whoever receives a report or record of child abuse knows how to appropriately respond and handle the information given. The report must be responded to promptly and with discretion, and they felt that a higher senior administrator in a sporting program would be more appropriate than a coach. That is the only amendment that they've been seeking.
Okay, thank you so much. I appreciate it.
Thank you.
Are there any questions about the bill and the amendments? Go ahead, Delegate Bartlett.
Thank you. I have one question regarding the proposed amendment with respect to coaches. And my question is, and I'm sure it was taken into consideration, but I just want to hear the answer. With respect to, coaches have children on their own a lot, like they travel or whatever for a game or something. So how did you all take that into consideration? That sometimes it's the coach who needs this information because they are on travel, or is it just the administrator would provide that information to the coach if necessary?
That's
Okay.
it. The senior, yes. Yes,
Gotcha.
ma'am. That's right.
Okay, thank you.
Any other questions?
No.
Okay, go ahead, Delegate Valentine.
Madam Chair, I'm actually reading off my notes and I'm glad that this was touched on. I have a coach or a manager highlighted in my notes as a problem. And I echo the same comments of such a low level individual in the organization. I just wanted to mention that as well.
Okay, all right. Go ahead, Delegate Pastor. I see your hand.
Wait, I can't figure out how to do that other little hand. I just want to chime in my agreement because often coaches our neighbors and, the community people. And I don't think that they should know that level of information. And I found working with coaches that I would know. I knew when there were issues, and we could always find a way to share with the coach, what some look fors or some concerns without giving that very private information. And it worked. And I also found that many of the coaches didn't really want to know anyway. They want to do what they do. They just want to make sure everyone was safeguarded. So I just wanted to put my 2 cents worth in with agreement and know that it does work without them knowing at that level.
Thank you very much, Delegate Pastor. I guess I have some questions and probably some concerns. I noticed again from this is very broad language that we're talking about disclosing this kind of information to. I mean, if we look at let me see. On page 4 within the bill, we talk about disclosing this to the administrator or other appropriate personnel of any organization that provides adult supervision or care and control of children. And so I guess I want to understand a little bit more, maybe Ms. Wilson or even Ms. Phillips, kind of what the thought pattern is here. I mean, maybe the question really is, why do we have a need to disclose information about neglect and child abuse to such a broad range of people? And I know there's the amendment to take out the coaches, but I'd also like to understand what the thought is behind confidentiality of this information, because that's pretty critical. And just again, just kind of what are the guardrails around this? So if someone could comment to that, I'd really appreciate it.
Absolutely, Chair Crutchfield. Our intent in seeking this change was to ensure that other organizations that provide care and custody for children also have access to information regarding an indicated finding of child abuse or neglect on behalf of one of their employees. So currently under the law, the Department of Human Services is allowed to disclose to school systems whether an employee has been found to have an indicated finding of child abuse or neglect, but they cannot make that same disclosure to a similar organization, such as your government organization, your youth sports organizations, or other organizations that provide care and custody to children. So just making sure that these individuals are being identified wherever possible to keep them away from students.
Okay. And then what about the confidentiality piece of it as well?
Absolutely. As far as confidentiality, we'd be looking for the same confidentiality that school systems are held to, which means that a redisclosure could not be made. So this is simply a notification from DHS to the employer of this person, and no disclosure further than that. Okay.
All right. And currently, DHS, what do you guys do right now as far as disclosing? And this is usually, and you guys do it under a very specific range of times, right? Investigation, it has to be requested. So tell us a little bit about that.
Correct. So it has to, as Grace mentioned, it has to be indicated. There has to be like substantiated evidence that there is abuse or neglect has taken place. And then we would inform the school system that one of their employees has a record of abuse or neglect. So we actually sat down with Grace, and we sat down with Delegate Wilson 2 weeks ago to kind of talk this out and kind of get at the heart of what AACPS is kind of looking at. From my understanding, and Grace, correct me if I'm wrong, but the concern is that there, as Delegate Pastor has pointed out, we have coaches who are a part of the community. They're part of being involved with children, and so they might not necessarily be employed in the sense of being paid, but they might be a volunteer coach. They might work volunteer at the YMCA or be involved with the local Parks and Rec League. And right now, there's not necessarily a mechanism to notify that organization in the middle of a season. They can certainly order a background check in advance of the season, if there was substantiated evidence that this person had in fact a record of abuse or neglect against a child. So this sort of is an attempt to address the space in between the start of seasons. Justin actually coaches his son's baseball team, so you can kind of talk about what that process looks like. You know, you before you even start, you would be submitting to a background check, but you know, what happens if the investigation is happening in the middle of the season and that evidence kind of comes to bear while you're in the middle of baseball season, right? So it's good. That I hope that kind of answers sort of where like Delegate Wilson and AACPS is seeing sort of a gap in communication and notification about whether or not someone who's working with children, you know, may in fact be someone that needs to be monitored more closely.
And this is also for alleged child abuse or neglect. This is not for convictions alone. This is for, okay.
Correct. The way that the bill is drafted, this would be a broader swath of reports and records that we would be disclosing. Now, I don't know if we sat down with Delegate Wilson and he had requested that the department draft up some potential amendments to sort of tighten up some of that space. I don't know if he submitted that to you all. No? Okay. Well,
yeah, we have not received any amendments. Okay, so he was going to okay, so that, all right. Yeah. So typically, I mean, I guess I want to make sure, because it's been a long time since I've had little kids playing in any sports or anything like that, but I know that for most of the sporting activities, there has to be a background check. And I would assume even, you know, most employers who, I mean, for example, obviously licensed childcare providers, all of that, also do background checks. So things will come up. I mean, and again, it may not be a conviction, but there may be something to indicate that a charge was filed. But again, we're trying to get into some of these other spaces as well, is what you're mentioning, right?
That's, I mean, I would like Grace to speak to that, but yeah, I mean, a background check is going to be a criminal background check. There would have to be an actual indicated finding. There would have to have actually been evidence and conviction that this individual is guilty of this. I think the way that the bill is drafted is a much broader and more of like, hey, we're raising a yellow flag against this individual. Which I think sort of speaks to some of, you know, what you voiced about concerns over confidentiality or, you know, the level of which that disclosure may impact a community member.
Yes, and it also, I guess, another concern is that once that employer has that information, it's really on them what they do with it. And so you could even get into issues around negligent employment, all kinds of things. If they receive the information and then they don't react to it, if you understand what I mean, if they don't do something about having the information. So I don't know if it's just an expectation that the employer knows. We want to dive deeper and understand what that investigation looked like, or what, you know, whatever the child abuse or neglect was. But is there some true expectation of what a person should do once they get the information? I think this was raised earlier.
I mean, I think from our end, it's if the point is just to sort of like kind of
knowledge. Yeah,
just sort of, like I said, raise a little bit of a flag and say there might need to be, you know, more oversight here. Right. You know, we're not asking, we're certainly not asking, you know, Parks and Rec organizations and volunteer sports leagues to become law enforcement and sort of police their coaches over, you know, just a report disclosure. But I also think, you know, we're also looking at, you know, the very clear difference between whether or not you know, the person that this is disclosed to is actually equipped to make a decision about what the right path is and what to do with that information. So I think to the earlier point about the one recommended amendment, you know, is a coach really the person to disclose to, or is it more appropriate to sort of go higher up the hierarchical chain? But then again, you know, speaking to like local Parks and Rec, I don't know that individual that's running that unit really necessarily has the education or background to really be made responsible for what to do with that information and how to respond. Yeah.
Got it. And there was also, I think, some interest in possibly losing federal funding if this is done without intent involved. Could you talk a little bit about that?
Sure. So we have the CAPTA law that this is the committee has discussed before, which has to do with our records disclosure and making sure that we're properly making available records of abuse and neglect. And so in our discussion with Chair Wilson, we had talked about some clarifying language that would tighten up that intent so that we're clear with our CAPTA funding. The legitimate, it has to have a legitimate state purpose in order for us to disclose. And so we needed that to be in some way tightened up and defined in the bill, which is why, you know, we had made some recommendations to him. I can certainly circle back up with his office if you'd like us to, but we did provide him with language recommended by our AAGs to sort of define that legitimate state purpose and keep our CAPTA funding tight.
Okay, thank you. And Delegate Pastor, I see your hand. My apologies. Go ahead.
No problem. I know I'm feeling a little unclear here about what is wanted and how if you get just the flag, you know, that says something might be wrong, what was just said in terms of what folks will do who are the people who are over the institution, whether it's Parks and Rec, whether it's a daycare, what is it that you're saying that is supposed to be done, or what you're trying to close? Because I've seen way too many times, one, when there was a yellow flag and folks did nothing, and it became something bigger than that, or knowing that some places, when you do a background check, that some folks, because when checks are done, we were always told, you give yes, no, you're essentially very vague in answering the question, so you don't get caught up in all sorts of other legal things, even though we always found ways to let the interviewer know what was in our head, that there was a problem. So sometimes, and we keep seeing it over and over, I again use the poor man at Pikesville High School. So, you know, and we see that with coaches, we've seen it with other folks. So explain again what it is we're saying that we're telling people that they are to do when they're flags, because we can't take back once something happens to a child.
Anybody want to answer that question?
I can try, Delegate Pastor. I think from Anne Arundel County Public Schools perspective, we're not looking to dictate what an agency does if they're informed that there's a report of ongoing child abuse or neglect. But however, if there is an indicated finding of child abuse or neglect, we think those individuals should no longer be working with students.
Thank you, Grace. So I think as far as what would we expect that organization to do, it's we're not expecting them to do anything, because this is just us disclosing reports and records. They would still be required under existing law if they knew of some maltreatment or abuse or neglect that was happening. This bill doesn't impact that. So I think if I'm not mistaken, the goal is just to sort of give these nonprofit organizations with volunteer individuals who aren't, by legal definition, they're not employees, but they are working with children to sort of let the organization know that the individual might have a report that maybe they are being investigated, or maybe they're not. Maybe this would allow us to disclose.
Does that answer your question, Delegate Pastor, or do you have a follow-up? Or, okay. Just not sure. Got it.
No, I'm sure. I'm sure what's in my head. Thank you.
All right, Delegate Valentine. Thank you, Delegate Pastor. Go ahead, Delegate Valentine.
Thank you, Madam Chair. My question kind of goes along similar lines. If we're divulging that there's an investigation ongoing, or that there was an investigation, or if there was a finding, are we also divulging that if the case was unfounded? Would these organizations be told that there was a case and it was found to be determined to be unfounded as well?
Okay, so I mean, the way that we read the bill, the way that it's drafted is that's not what we're disclosing. We're just disclosing that there is a report or record. So, I mean,
Something exists.
Something exists.
Okay.
Now, I mean, that seems probably a little bit irresponsible. So we might want to, if it was the will of the subcommittee or the full committee, to consider how to tighten that up. Because I certainly think to just sort of say, well, here's evidence of a report or record, and then no follow-up to say, oh, it was ruled out, it wasn't indicated, there is no substantiation to this. That's quite a challenge for somebody just coaching Little League, right?
That's what my thought process is in a small town Little League setting, and there's a record that exists because there was an allegation made or wasn't made, and that this case was unfounded through your investigation, but you can't reveal that. I think that does have some effects on those organizations and those coaches. But I thank you.
Thank you. So Delegate Taylor, I think you were next.
Well, Delegate, I have a question as well. I know I don't have my camera on.
Sure, yes, I see you, Delegate Sample Hughes. I do.
Thank you, Madam Chair. I guess my question is along the same lines as Delegate Valentine. What I have written here is accused or convicted. Like, are we, what's in a record? Is it an accusation maybe that could follow a person, or is it actually a conviction, or, something that was founded that was in a record? And then can somebody speak to how long that stays in a record? So if this person is now 60 years old and maybe the abuse happened at 18, is that still in their record and may show up? Be they accused or convicted or the abuse founded?
So I think the bill, and I'll just start out, I think the bill talks about reporting everything. So in other words, if it's an allegation, if it's a conviction, that's what's going to be reported. As far as staying on the record, I think that all depends on how that person, if they are on, some sexual, some kind of other record, right? Some kind of registry, or if there's something else involved. And again, it just depends on what the charge was and what the conviction is. So.
May I follow up with something?
Sure.
So we've had discussions about commissioners a lot and what they're allowed to do. So could, this as a hypothetical, go to a commissioner because I'm accusing my boyfriend of abuse, right? Of abuse of my child. But we've had a bill out there that says, this person is abusing that privilege of going to a commissioner. They're just coming back and back and back. Well, the person on the other end now has these piled up allegations that didn't necessarily go through the courts, but may have just gone through, a commissioner. I'm just concerned that, I think we called it a scorned spouse or, partner that may have these charges piled up on their the other partner, and how long they stay on the record. That's all. I just wanted to throw that out there, something that's in my head and why I'm a little reluctant.
Yes, understood. I mean, yes, I mean, I could see that happening as you describe, someone having multiple allegations made against them, but nothing has actually been at a point where a state's attorney would want to take action. So they're just sitting out there. And the question is whether they could be expunged, whether they could, do they sit out there for a long period of time? I don't have that answer for you. But nonetheless, you're right. I mean, it's out there and it's on the case search and all of that. So it's out there, so. Okay, Delegate Sample Hughes, you had a question?
Sure, thank you. It's actually on the same lines of Delegate Valentine. That was the question that I had, but I wanted to take it a step further with the department. What is the current mechanism, or is there one way to notify the party that there is an allegation, or say the employer, but then nothing was founded? Are you currently sending a notification and saying nothing's going to move forward? Are we doing anything at all in that area, or you're just speaking just a while ago, were you just speaking to this actual bill that you think that we should do something?
So I mean, right now it's sort of the facts come in, they're assessed by our Social Services Administration, and they sort of weigh, measure, and rule things out, and then they may rule it out and say this is unsubstantiated, or they may say there's enough information to indicate that we should begin an investigation. And so that's where it sort of splits, because even then an investigation may happen, and the concluding facts of the investigation are that, this individual is not guilty of crime.
Right, but is my employer notified that you didn't find anything whatsoever?
Your employer wouldn't be notified until there was a conviction.
Until of a conviction. Okay, I thought it was at the alleged point.
So the schools can request these records, but I mean, that would, and Grace could probably speak to this better than I can. One would have to have some sort of reason to ask that question in the first place. So, I don't think we're trying to be very, very careful about the confidentiality that each individual has a right to, especially because the way that the investigations split between us receiving an allegation and how we do the assessment and how that takes time to look at all the information that we have. We're not just running around telling employers, hey, by the way, we got a call yesterday about, Bob Smith. So I think the results would be what would be finalized as of right now. We're not just issuing disclosure of reports without any kind of substantiation to a school.
Okay, but this bill speaks to doing that though, right?
It does, and it opens it up to several other types of entities and organizations.
Okay, thank you so much. Thank you, Madam Chair.
Yes, you're welcome. And go ahead, Delegate Simpson.
So how would you recommend tightening it up so that it was more in compliance with what you do with others? Or is there a particular hierarchy that you would think would be better? I mean, I understand the point, the goal they're trying to receive, but I definitely can see the concerns of just providing this out there of saying, oh yeah, we got a call or whatever. So how would you tighten this up? How would you amend this?
I I don't want to overstep since apparently Delegate Wilson did not send these over, but we do have some options I'm happy to send over to the subcommittee if you would like. Among which is to add some language that talks about that the purpose of the disclosure would be to determine the suitability of an individual for employment, specifically in a child care center. So we would address that section. And then work on some other language that has to do with the purpose for which the organization is functioning. So in the context of like the sports coaching, management of youth sports, it would be organized for recreational athletic competition or instruction for participants. So we're defining the role of the individual and the role that they have in the child's life, and bringing that under the definition, and then tightening that up there so that we're addressing situations where individuals under the age of under the age of 18 who are under the effective care and custody of an adult still receive that kind of protection. And then we specifically name like temporary care or custody. So for example, like those who do have like traveling sports where the coach is alone, or maybe not the only sole adult, but certainly has extended time with these youth and is responsible for the supervision of the child, to then determine the suitability of that individual, not just for employment, as I said before, but even voluntary service with the organization. We think that is really important, because it's one thing to say that, somebody should not be employed and receiving a salary or an income from their time having supervision over a child. It's a little bit different ballgame when we're talking about volunteer service, and how you control some of those volunteer opportunities and organizations, and how they function and how they choose to operate. So I'm happy to send this language over to all
Okay,
of you.
that would
You
be
think
great.
That would be helpful. Sure.
Yes, that would be great. I think in the interest of time, we're going to go ahead and wrap this up. Delegate Pastor, if you'll, is your question really brief? I can't hear you. You're on mute. You're on mute. Unmute.
My last question is this. And I said all my questions were brief, the answers were just long. So is this bill strictly about the child information we're getting and to whom we give it? Is that the end of the bill? Because Delegate Valentine and also a couple other people, but starting with Delegate Valentine asked, what about the employee? So is this bill also taking into consideration that now information is out there, whether the person is guilty of something, not guilty of something? So does that include what happens to the employee? So does the employee know, or everybody, whoever the person was who was told, now know that there is no there, if you will? So I'm just trying to zoom in on
Got it.
exactly that.
So let me say this, because the bill was a little confusing in that I think the bill, and please correct me if this is not correct. I think the bill is really about disclosure to employers more than anything. Is that correct? Yes. So it is about whether someone has a child neglect, child abuse, I want to say encounter, or because it's not necessarily they've been convicted or anything, but they've been charged maybe. But it's about that disclosure, that information being disclosed to their employer, because they are in an industry where they deal directly with children. Is that a pretty good synopsis? Okay, thank you. So that's what it is, Delegate Pastor. You're right, because the way it's written, it kind of makes it appear that we're talking about disclosing information about the child and the child abuse. But I mean, we are, but it's regarding that particular individual's charge regarding child abuse or neglect. Okay. Does that answer your question? Okay. I know. All right. So in the interest of time, and it appears there's some amendments, more discussion possibly about this, I'd like to adjourn our subcommittee. And so do I have a motion to adjourn?
I motion.
All right. Great.
Second.
Thank
Second.
you. Thank you. Okay, so we're going to adjourn and, like I said, take this up again, find out a little bit more about the amendments and what are the other pieces to it. And if there are other questions, we can get that done as well. Thank you, committee. We'll see you